Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guests.
I'm very pleased to welcome you to our program, and our topic today is religion and the First Amendment. And we really have a very fine authority and expert to discuss this important question. As you all know, for years we've talked about what does the Establishment Clause in the First Amendment mean, as well as the Free Exercise Clause. Religion is a very important component of the First Amendment. I welcome to the program Dr. Gene Strawn, who is a member of the faculty at Lewis Clark State College teaching in justice studies, which includes areas of political science and also certain criminal justice questions. Dr. Strawn, it's great to have you back. We had you on the program a few weeks ago, and I'm so pleased you can be here. This is a real expertise for you, and I've heard you present on a number of occasions, and we're grateful that you will share your thoughts with us today.
Thank you.
And as always, I'm very pleased to have our two regular panelists, Janelle Burke, who's an attorney in the state of Idaho, and next to her is Steve Schink, who is the Vice President of College Relations and Development at North Idaho College, and Janelle will commence today's questioning.
The First Amendment is very interesting, and all of us believe we know what it says, but can you tell us what it says, and then define for us the two clauses that are in the First Amendment?
Well, sure. It starts off by saying Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So I guess the question becomes, well, what do we mean by respecting an establishment of religion or prohibiting the free exercise thereof?
So those are the two clauses, the
Yes.
the establishment and the free exercise.
Right.
Yes.
And they really push and pull in different directions. Now, there's great disagreement over what they mean. But clearly the idea is we want to make sure that the state is careful and avoids benefiting religion. Establishment clause, you can't establish it. No law respecting an establishment.
And give us some examples of establishment.
Well, for example, if we were to establish a state church, all the justices agree that if you were to single out a particular religion and establish that as really a national religion that we all had to pay taxes to or support, which was the case in Europe at the time that many of the colonists came over to America, that would clearly violate the Establishment Clause. That's obviously benefiting a particular religion. More interesting question comes up, well, what if you benefit religion in general? All religious groups. And then what do you even mean by religion? Does that include Muslim groups? Does it exclude Muslim groups? Does it include Native American groups? Or are you only talking about benefiting in general Christian groups or Protestant groups? The Free Exercise Clause pulls in a very different direction. The Establishment Clause says you can't benefit religion. The Free Exercise Clause is concerned about burdening religion. And again, all the justices agree that if a government was to single out some religious practice and just discriminate against that religious practice and prohibit that particular religious practice, and that particular religious practice poses no risk or threat to public safety or the rights of others, that would be discrimination and that would violate the Free Exercise Clause. The more interesting question, though, is what about if you burden religion in general or certain religious groups? You don't single out one particular religion, but it affects a lot of different religious groups as well as secular practices.
Steve Schink.
Before the show started, Dr. Strawn, I promised Tony that I would try today to speak for the common person in our audience. I'm in a studio here with two political scientists and an attorney, and I'm sure you three could happily talk for 30 minutes about the fine points of constitutional law. But how do these issues really affect people? If you would cite some cases and talk about decisions that make a difference in the lives of churchgoers in America, what would you speak to?
Well, I guess in terms of the Establishment Clause, there are so many cases we could talk about, but certainly Engel versus Vitale, 1962, and the cases that have followed involving school prayer.
All right.
Where you have a student who says, you know, I'm at a public school paid for by taxes of the public school, and there's a teacher leading a prayer or another student leading a prayer, and it's somehow organized through school officials and school authority. That is really unfair. It makes me feel like less of a person. It makes me feel like an outsider. You're not giving me equal concern and respect. So that has a tendency of establishing or promoting or benefiting a particular religion, or maybe religion in general.
What about a case on the free exercise side?
Well, I guess probably the more interesting one that I would think of recently that has had profound effects in constitutional law was the one where the Supreme Court was taking a look at the issue of Native Americans ingesting peyote. And for hundreds of years, as part of their spiritual practices and their religious heritage, they have ingested peyote. And in fact, they ingest peyote under the confines and the supervision of the Native American Church. And so any law prohibiting that or interfering with that gets us at a point where we kind of feel how people's free exercise of religion is burdened.
Thank you for those examples.
You're welcome.
At the risk of having my colleagues upset with me, I am going to get more specific. Steve is just so wonderful, and he was having some fun.
Go ahead, Tony.
But
I'll just sit here and try to keep up.
Okay. You have tables 1 and 2 on the board, and we're going to ask our camera to zero in on the top one, if they would, please. And table number 1 says judicial voting trends for the establishment decisions. And if, Gene, you take a moment to talk about that. What I see when I look at that chart in my studies in the area of constitutional law is that when you look to the left there on the chart, you see Douglas, and you see Black, and you see Brennan, and Marshall, and they're together. You go to the other end, and you see, for example, Rehnquist and others that have a different philosophy, way off on the other end, and we have it on the screen now. There has to be a reason why over time, when justices are on the court together, that there is a rather high consistency of disagreement between them on some key religious issues. Would you show that and explain what you think it is?
Sure. Well, there's been about 60 Establishment Clause decisions decided by the court. If you go back and you look over the last 40 years, you look at the Rehnquist Court, and that name is after Chief Justice Rehnquist, or the Berger Court, Chief Justice Berger, or the Warren Court. And courts before that, you see some clear trends. Scalia and Thomas and Rehnquist and Kennedy White and Berger will rarely find a violation of religious liberty under the Establishment Clause. They'll rarely agree with the claimant who is saying, you know, whatever government's done here, it's an establishment of religion. But they will oftentimes favor the government regulation or government power and allow that promotion, that benefit to stand. Now, it's just the opposite when you start to compare people like Ginsburg, Douglas, Brennan, Marshall, Stevens, Black, and on down the line. And you need to be careful here, too. I mean, some of these justices like Douglas and Brennan, you see how many votes they have cast, 21 for Brennan, 42, 42 for Brennan and 35 for Marshall. And then over here, you see like Scalia, for example, he's cast 17 votes, Rehnquist, 44 votes. And you see very similar things in terms of the free exercise decisions. Again, there's been about 60 of those. Well, the general explanation for this is if you read the opinions carefully, what you'll find is they interpret the religion clause differently, but they interpret them consistently. Justices on this side interpret them in a way that allows government regulation, either to benefit or to burden religion.
I'd like to ask our camera to move down to the second table, table 2, and I want our viewers to see again that trend. And again, you have the same justices on those two sides. Isn't this one of the reasons why when there's a nominee before the U.S. Senate, there is oftentimes such a debate over whether that person will be confirmed depending on whether they are a judicial activist or a judicial self-restraint, or how they would interpret the Constitution?
Absolutely. The Establishment and Free Exercise Clauses are like other provisions in the Constitution. Not necessarily in statutes, but in Constitution. They're very general, they're very vague. They contain elusive language, largely because the founders themselves could not agree. And the history also is dichotomous, meaning that there's different interpretations. So when justices are deciding establishment or free exercise cases, they're looking at those provisions, the language, they're looking at the history, which isn't real clear, and it allows for different interpretations. And they're also looking at facts and precedent, and yet they're disagreeing. And they're disagreeing on a consistent basis over time, and so something is motivating the disagreement. When you read the opinions, you find they interpret the clauses very differently. Some interpret it, a Brennan, for example, to allow greater protection to religious liberty. And his voting patterns are very clear.
And he also votes more often on separation of church and state, that is,
That's right.
ruling against the state being involved.
Absolutely.
On the Establishment Clause.
Right. And then on the Free Exercise Clause, he's also ruling against the state and not allowing that regulation of free exercise of religion. If you compare Justice Brennan's record to someone like Rehnquist, Rehnquist has heard a lot of cases, and only 4 times has he found a violation of the Free Exercise Clause.
So he rules more often in favor of allowing the government to regulate in areas like the example you gave, in which the court said that Oregon could pass a law if it wished to prevent the use of peyote in a religious service by Native Americans.
Right, and he ruled against the Native Americans. Brennan, on the other hand, ruled for the free exercise religion of Native Americans. And you find those same trends in Establishment Clause. I mean, it's kind of interesting to look at Thomas and Scalia. They've never found a violation of the Establishment Clause. And Scalia has heard 17 cases, and Thomas has heard 9 cases. And in many of those cases, justices over here on this side and on this side had found violations of the Establishment and the Free Exercise Clauses.
I have one other question before I go back to Janelle. And there are other things in the First Amendment that are terribly important: free speech and free press and right to assemble and so forth. Thinking of Justice Douglas, for example, he's on the court. He was such an interpreter of the First Amendment when he always stressed those words, Congress shall make no law. So he very much opposed censorship. He didn't like government regulating the distribution of information. Have you looked into that and saw that same kind of trend between the judicial activists and the self-restrainers on other issues like free speech and press?
Well, you do find in the area of freedom of speech justices who are concerned about protecting religious liberty. They'll also be concerned about free speech. This also goes in the area of criminal procedure. Justice Douglas, on a regular basis, has found violations of the Fourth Amendment, unreasonable searches and seizures. In the same cases, Justice Rehnquist and White, Berger, they've said, no, that's not a violation of the Fourth Amendment. So you do find those similar patterns and trends in all the different areas of constitutional law. The only caveat here is, because you brought up free speech, in free speech cases you find a lot of the justices, even some on the side of typically ruling for government, to side with freedom of speech. And I think there's some different reasons to explain that, but those patterns can be felt throughout constitutional law.
So that's more likely to happen on speech than it is on religion with some of the judicial self-restrainers?
Yes, it is.
But one final conclusion. From your study, wouldn't it be accurate to say that judicial activists are more likely to want, in those areas, to limit government and judicial self-restrainers to give government more leeway to make policy?
They are, but let me comment a little bit on restraint and activism. Activism means that a judge goes out of their way to kind of strike down a law. And so you'll a lot of times hear the word liberal used to describe an activist. And a restrainist means a judge, defers to government authority, isn't interested in striking down a law. And you'll oftentimes hear the word conservative because they want to maintain the status quo. I've got to tell you that in some freedom of religion cases, justices like Rehnquist and Scalia and Thomas and White and Kennedy have actually struck down laws recently, for example, that actually gave greater religious freedom for free exercise purposes. They literally struck down the law and said, no, we don't want that law because we think that goes against the way that we've interpreted the Free Exercise Clause. So sometimes, even what we think of as conservatives, they become activists if it fits, I guess their policy preferences would probably be the best use.
But that's
of
been
words.
more likely to happen in the free exercise than it has in the establishment.
Yes.
Okay. Janelle Bird.
But you will agree that all of this is very complicated, and it's not easy to just look at things and label them in any way, shape, or form. Now, of course, when a case goes up to the U.S. Supreme Court in particular, and that's what you've studied here, the justices are free to deny a hearing to the case. In other words, they don't have to grant certiorari. So they wouldn't have to hear a case if they do not choose to hear it. So there may be many cases out there that they don't hear.
Oh, absolutely. I mean, there is discretion not only in interpretation, but in the decision to hear a case. The rule of 4 applies, as you know, and 4 of the justices have to agree. And there can be all kinds of reasons that they actually will bring a case up, and all kinds of reasons that they won't bring a case up. And there is discretion within certainly the granting of certiorari, like there is discretion within interpretation. And we have to be very careful. There is, make no mistake about it, the law matters. Precedent matters. The facts matter. Certain facts in a case, you'll get all the justices saying, you have singled out religion, targeted it for discriminatory treatment, and that violates the Free Exercise Clause. We're not going to allow that. So facts matter. But what's interesting, of course, is that the disagreement among the justices creates some very different interpretive theories. And what you find within the decisions is a real distinction between laws with the purpose of discrimination and laws with the effect of discrimination. And I'd certainly like to talk a little bit about that distinction.
Why don't you go ahead?
Okay. Basically, judges that grant government discretion and allow government to regulate more, either in terms of benefiting religion through the Establishment Clause or burdening it through the Free Exercise Clause. What they are doing is they are interpreting the clauses as prohibiting government to purposefully target religion, either for a benefit or a burden. So that's how they narrowly interpret the clause. Well, what does that leave open? They allow government to burden or benefit religion as long as it doesn't single religion out, but as long as it passes a regulation that's part of a generally applicable law. So as long as it doesn't say we're going to establish parochial schools, that would certainly violate the Establishment Clause. But if government passes a law that says we're going to allow textbooks to be bought for all schools, including parochial schools, then the justices who interpret the Establishment Clause as only the purposeful, prohibiting the purposeful benefit, will allow aid to flow to these parochial schools as long as it's part of a generally applicable program, even if 85% of the aid that goes to the schools goes to a religious schools. On the other hand, the justices who are much more concerned about maintaining religious liberty, they interpret both clauses to prohibit government not only to purposefully single out and target religion for a benefit or a burden, but also, and this is the key, to pass any law with the effect of doing that. So that if you were loaning textbooks or if you were building buildings for all schools, you couldn't send that to parochial schools. You'd have to limit the type of government assistance only to secular schools, because the effect of that law is to benefit particular religious groups.
Well, I certainly agree with Janelle. This is complicated, and I'm going to try to stick to my trend here of asking questions that I hope benefit the audience. What you've done is chart voting patterns on the Supreme Court, and not a huge surprise, I guess, we have a liberal-conservative split on that court, something that we know about and have talked about for years. How is this information useful to you? How does it affect anything that the Supreme Court might do in the future?
Well, I think that's an excellent question, and the next chart gets to that very issue. Let's take a look at it. What the next chart kind of does is show over time what the Supreme Court has done in terms of the Establishment Clause and the Free Exercise Clause. And as you see, over time, the Supreme Court has become much more willing to allow government to either benefit or burden religion, and much less willing to protect religious liberty. And the reason is because more and more justices today are interpreting the Establishment and the Free Exercise Clause as allowing government to regulate religion as long as it doesn't do it purposefully. All right? In other words, I can benefit religion and I can burden religion, but what I can't do is single out religion for a benefit and burden. What I can do instead is pass a generally applicable law that has the clear effect of doing that. So what that means is the politically powerful people who are able to go to the legislature and able to say, you know, we're an organized religious group, and what we kind of like you to do is pass a generally applicable law that, say, provides some kind of service or assistance to us. Now, we know the effect of the law is essentially going to help us out more than other people. So, for example, if we get back to the aid to parochial schools, you might pass a law that pays for the secular education component of parochial schools, which, by the way, parochial schools are certainly an important foundation of our educational system. And as long as that law simply said, any school out there can receive such and such assistance for the teaching of mathematics class or a biology class, then it's a generally applicable law, and that can end up flowing to parochial schools. So that means one person's tax dollars, who may not identify with that parochial school, will be used for that particular classroom. And what the court has done is, based on this interpretation, is allowed a lot more regulation or government benefits and burdens to flow to religion. And it's created this situation that now people can go and lobby the legislature to pass generally applicable laws that either benefit or burden whatever group that they're interested in. What does that do as far as other groups that aren't as powerful? Well, that means that they're going to be probably largely subject to those kinds of burdens, and also because they don't have the power to lobby the legislature to get that kind of treatment, they're probably going to be kind of subject to having some of their tax dollars used for things they may not want them to be used for.
If I may ask one more quick question before I get back to the experts. As I read those charts, and you go back 100 years in these comparisons, and it doesn't look like the blocks of time are not equal. So this is going to be a little bit wrong, but it almost seems like we're returning to an earlier pattern of voting. Is that, am I interpreting those correctly?
Well, you're very astute, actually, because one of the interesting things that I argue in my research is that the Supreme Court's new interpretation, you can't regulate religion purposefully, but you can do it if it's part of a secondary effect of a generally applicable law, really takes us back to a point in time where religious liberty was something that the politically powerful had, and the politically powerless, it could be given and taken away by whatever the legislatures decided, as long as it was a general policy that applied equally to everybody. And we are in a situation now where religious liberty for some groups is at risk, for example, for Native Americans, for Muslims. But it's not just them that we need to be concerned about. I'm actually a Roman Catholic, and I'm certainly, I want the parochial schools to benefit as much as they can, existing within our society. But the interesting thing, of course, is if you start passing government assistance to parochial schools, or just to private schools, 85% of all private schools are parochial, and Roman Catholic make up a large percentage of that. So we're going to benefit from that assistance. But be very careful, because when government comes in and starts to give you money to further the religious cause, what starts to happen is there are certain conditions that are attached. And I particularly wouldn't want a biology teacher in a parochial school to be told, well, listen, when you teach evolution, whatever you do, don't talk about the book of Genesis, because we paid for those biology books. And don't talk about creation science, because we paid, government money paid for those biology books. So I actually think that not just the politically powerless are at risk, but also the politically powerful. Because when we all start to compete for government attention, divisiveness develops in society for scarce resources, but also the conditions to who gets those scarce resources.
Very interesting. Thank you.
He's very astute, you see. That proved it. He went
Yes.
up on the chart Steve Shink did and knew exactly what he was doing. That was just his technique. He's very astute.
There are little numbers up there. I can
Steve, you're very astute in this area. I just got to make that on record. In relation to this, history has taught us something that goes beyond the United States, and that is when there is an entanglement, and that term's been used in the court, entanglement between government and religion, oftentimes religious organizations find themselves persecuted later through regulation. I had the opportunity to visit the Soviet Union while it was a communist state and think, heavens, we don't have that system, and that democracy is the way to go. But what happened in that country when the czars formed an alliance with the Russian Orthodox Church, it corrupted both of them. And then, of course, with the fall of the czars, then religion found itself persecuted because there was a backlash and reaction to that. So I'm just making a point that for those who have great love for their religion, you're saying there's a caution here about how much you want government involved that could affect your deep religious beliefs.
Oh, absolutely. And I think it's the excessive entanglement consideration is one of, we certainly don't want to create an atmosphere where religious groups are denied benefits that don't in any way, shape, or form promote religion. So parochial schools, in terms of maybe receiving bus transportation or maybe receiving fire and police protection, we wouldn't deny that to them,
right,
because there's a safety concern about giving that to them. But notice that that's given to everybody. And there's also a safety concern. But the minute we start either promoting religion or interfering with religion, burdening it, and we're doing it just because it's something that the political majority wants, you have to be careful what you wish for, because what you might get in the process is a lot of government regulation and government interference. And I'm really concerned with the notion of watering down religion. There's some interesting Supreme Court decisions in the area of the Establishment Clause in it, and they deal with nativity scenes. Mm-hmm. And the Supreme Court has said, well, if you throw in a reindeer, and if you throw in a Santa Claus and a Christmas tree and some carolers next to the creche, the nativity scene, that kind of takes out the blatant Christian message. Well, I don't think that a Saint Nick or a Christmas tree takes out the religious message, but I don't want the religious message taken out in the first place. And I think when you get government to start promoting religion, if they try to soften things, if they try to water it down, then it takes the very meaning out of that significance for religion.
We don't have a lot of time left. We don't have time to get into this, but I'm very fascinated with the lemon test that the court has used. Based on what you're finding and what Steve just pointed out, where we were many years ago and where we've been and now where we're going again, in the most recent cases, how much is the lemon test still valid?
Well, I have to tell you that the Lemon Test and this
3-point lemon test.
Pardon yeah, I mean it requires a government regulation to have a secular purpose. It requires the primary effect of the regulation not to benefit or promote religion, and it prohibits excessive entanglement between church and state.
It can't promote or hinder under
Right.
the second point.
But I've got to tell you that the Lemon Test has largely become, pardon the pun, sour. It's a bitter taste in many of the justices' mouths. They haven't been using it actually much over the last 10 years. And you know why? Because the effect prong flies in the face of their interpretation. And they're mainly focusing on, is the purpose of this law to advance religion? All right? And what they want to say is, we don't care if the effect of the law is to advance religion, but we care about the purpose, and you know as well as I do. Legislators don't usually overtly discriminate and try to benefit one group and burden another group within a law. They're bright people, and instead what they do is pass laws with the effect of treating groups differently. But most of the justices aren't using it, except for those justices who are still concerned about protecting religious liberty.
But in its original form, on the separation of church and state question, they were very cautious about not trying to advance or promote a certain religion or religions, or to hinder it, or to.
Right.
And so you're saying that may not be the trend in which we're going, that there'll be more involvement?
Yes, I mean, it's a lot of the justices like Rehnquist and Scalia and Kennedy have said this: the Lemon Test creates a catch-22 situation. Government can't give assistance to parochial schools like a textbook, but if it does, it's got to go in those parochial schools and make sure that those books aren't used to foster or promote religion. Well, obviously, we're not going to have government officials in the parochial schools, so what they've done is they've said, well, that's unconstitutional then, this catch-22. Now the justices are ignoring the excessive entanglement prong. They're not mentioning it, many of them, and they're also ignoring the effect prong.
On that note, I bring the program to conclusion. On behalf of our panel and our staff, thank you, Dr. Gene Stronny. It's been so informative, and we appreciate your being with us this week. It's a fascinating subject and terribly important to the future of the country. Again, thank you, and good luck in your work. Ladies and gentlemen, with that, we bring our program to conclusion today, and we've found it fascinating to talk about the First Amendment, two parts of it, on religious issues. Of course, there are other great issues within the First Amendment. Next week, we will turn to yet another subject, and I hope you'll join us that time. Until then, we'd like to wish all of you a very good week, and please be with us again next week. Until then, have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station.